House File 1467, otherwise titled the Defense of Dwelling in Person Act of 2012, has a couple of proponents that will change Minnesota's law. Article 2 addresses weapon seizure during states of emergency. This was prompted from the Katrina disaster when law enforcement went in and just confiscated law-abiding citizens' weapons. And in a time of chaos, we know that leaving law-abiding citizens undefended doesn't lead to very safe outcomes for them. So we are acting a little proactively here to get that changed for Minnesota. Article number 3 removes the duty to retreat that's currently in our castle doctrine law. Right now in Minnesota, if you are not in your home, you have a duty to retreat. If you're someplace lawfully, there are a great many of us that believe that you should be able to be there lawfully and that the onus should be on the criminal and not on the victim to be held responsible for their violent actions against another person. It also creates a presumption of reasonableness that protects the victim if they defend themselves. It allows victims to use force against violent felons, and it also protects victims from facing prosecution of lawsuits for defending themselves. And then the last article recognizes other states' permit to carry or licenses from other states.
The changes to the bill are absolutely sweeping and absolutely unnecessary. I would challenge anyone in this body. There's been an open challenge offered already to those in the public to give me one case where a person who has been defending themselves in the state of Minnesota has been prosecuted, charged, or convicted. They can't do it because it doesn't exist. It just simply doesn't exist. This is a solution, once again, in search of a problem that just simply doesn't exist.
Duty to retreat is, if you are in a situation, you have to take that split-second determination if you can run away or if you can defend yourself. And I think I used a really great example of somebody my age or any woman who would be in a situation where maybe the aggressor's in your yard, and yeah, maybe you could get in your house, but what if you can't? And I'm not willing to allow a violent criminal to prevent me from being out in my yard and having to think I've got to run in my house and protect myself. And so duty to retreat in this state means if you can get away safely, you should do that. But how do you determine that? Like I said, if a criminal has a knife and they're 21 feet away from you, before you can draw your gun, they will be on top of you. So how do you determine when that duty to retreat is? And that reasonable standard has to apply, and the courts will look at that, and that is their job.
It sounds like Senator Hoffman, or proponents of this bill, would prefer that we not have a duty to retreat at all, but she defines the duty to retreat completely out of existence, even though it does exist in current law. Members, a duty to retreat is if you can safely and reasonably retreat in a manner that would avoid the harm that you think you're facing. If you can't, under current law, you have a right to use enough force to prevent that harm. But if you can safely retreat to avoid the harm that you are facing, you have a duty to make that retreat rather than shooting someone else dead. That's current law.
This bill does not change our current law. This is about defending yourself if you are someplace lawfully. So anything that's in current law, if there's a prohibition in current law, this wouldn't supersede that. If you are someplace where you can lawfully be and you are threatened with a violent act, you should be able to defend yourself. And so that's what this bill addresses.